And I believe we have the examining authority here, so I'll hand over to them. Thank you.
Thank you, Mrs. Church. Good morning, everyone, and welcome. Today is Wednesday, the 17th of June, 2020, and the time is now 10:01, and Session 2, Part 3 of this first Compulsory Acquisition CA hearing is now open. This morning, we will be looking at site-specific CA issues centred around special category land and replacement land. My name is Gavin Jones, and I'm the lead member of the panel of examining inspectors appointed by the Secretary of State for the application made by Highways England for an order granting development consent for the M25 Junction 10 A3 Wisley Interchange project. I shall now let the other member of the panel introduce himself to you.
Good morning, everybody. My name is Graham Gould, and as Mr. Jones has indicated, I am the second member of the panel. As I indicated yesterday, I have got various phones going in the background because I have some issues with next to kin duties at the moment. And I am expecting that I may well receive a call or two during the course of today. If that happens, we may have to adjourn while I take those calls, but we'll deal with that as and when it arises.
Thank you, Mr. Gould. The other thing I should mention at an early stage is I don't know what the weather's like where you all are, but it's looking pretty thundery, and there's a chance of some thunder and lightning today, I think, certainly where I am. So that might give rise to some disruption of the event, but in terms of the technology, but we'll just hopefully deal with that as best as we can. Also present today from the Planning Inspectorate, and you've probably met some of them already. We've got Eleanor Church, KJ Johansson, Candice Patton and Richard Price. And Mr. Price will be doing most of the screen sharing of any documents that are required. Once again, thanks all for attending and thanks for accommodating the additional steps that are required. As most, but not all of you were present yesterday, I'll try and keep this as brief as I can. As I indicated yesterday as well, as this is a virtual event, there may well be some delays with document sharing, and we won't be able to proceed at the pace that we normally would, so please bear with us on that. I understand that Mr. Alderson has joined us via telephone today, in which case, as you probably heard, Mr. Alderson, it's please press *6 on your keypad to turn your microphone on and turn your microphone off. Thank you. I'll now get to the introductions, please. We've got quite a few people to introduce today, particularly from Highways England and Surrey County Council. So it might be best if we do what we did yesterday, Mr. Humphreys, and just introduce yourself to begin with and then bring people in as and when required. Does that seem a good way forward?
Yes, I'm more than happy to do that. And as with yesterday, if there's a problem with me having both the video and the audio on, please tell me and I'll just turn the video off. But so yes, I am Michael Humphreys. I am the barrister for Highways England. The one person, sir, who you might just get to introduce himself because he will have to speak is Mr. Andrew Shuttleworth. So perhaps you might want to invite him to introduce himself, but others will be on a more as needed basis.
Thank you, Mr. Humphreys. And so far, so good. You're coming across loud and clear in video and audio, I'm pleased to say. In which case, if we could get Mr. Shuttleworth to introduce himself into the hearing, please.
Good morning to you. My name's Andrew Shuttleworth. I work for Atkins on behalf of Highways England, and I've been assisting them with issues regarding replacement land, amongst other things.
Thank you, Mr. Shuttleworth. So far, so good. You're also coming across loud and clear. But again, if we do have problems, just turning off the video helps with the bandwidth issue, so it's much easier for us to hear you. But so far, so good. In which case, if I can turn to Surrey County Council, please. And first name I have on my list is, I think he was the first one in the lobby this morning, Mr. Ty, please.
Morning, Michael Ty, Surrey County Council. I will speak today if required, called upon to do so.
Thank you, Mr. Tar. You're also coming across loud and clear so far. Mr. Stemper?
Sorry, Mr. Jones, just before Mr. Ty moves on, can we just ask what your area of specialism, just so we understand, in terms of maybe directing questions at relevant times?
Property estates.
Thank you.
Thank you, Mr. Gould. The next name on my list is Mr. Stemfer.
Good morning, sir. David Stemfer, Surrey County Council, Major Schemes Manager. My role has been coordinating the County Council's response to the DCO. Thank you.
Thank you, Mr. Stemfer. Again, you're loud and clear so far. Mr. Mitchell next, please.
Good morning, I'm Steve Mitchell. I'm Countryside Access Manager for Surrey County Council, and I'll be introducing item 3 for the County Council.
Thank you, Mr. Mitchell. Mr. Whitaker, please.
Benjamin Whitaker, Surrey County Council, in the Estates team. I do not propose to speak today.
Okay, thank you, Mr. Whitaker. Ms. Jenkins, please.
Stephen Jenkins, Spatial Planning at the County Council, and I won't be speaking today.
Okay, thank you very much. Next person on my list is from Surrey is Mr. Edwards.
Good morning, sir. John Edwards from Surrey County Council. I'm the Natural Environment and Assessment Team Manager, and I can hear you loud and clear. I'm not intending to speak, but I will answer any questions if required.
Thank you, Mr. Edwards. And last but by no means least from Surrey, on my list anyway, I've got Ms. Forbes.
Good morning. Yes, Helen Forbes. I'm a solicitor with Surrey County Council.
Thank you very much. Is there anybody else from Surrey County Council, not the Wildlife Trust, the County Council?
Good morning, sir. David Stemfer, Surrey County Council. No, that is everyone. Thank you.
Thank you, Mr. Stemfer. That was everybody on my list as well. In which case I shall move to Surrey Wildlife Trust. Mr. Adler, please.
James Adler from Surrey Wildlife Trust, Director of Biodiversity. Not planning to speak today unless you want to ask me a question.
Okay, thank you very much. And I shall definitely make sure I don't forget you today. Mr. Garbett, please.
Yes, good morning, sir. My name is Ben Garbett, Keystone Law, representing Mr. Alderson with the Park Barn Farm Interest. And of course, I will be speaking today.
Thank you, Mr. Garbett, and I'm pleased to be able to report you're coming through loud and clear as well.
Thank you.
So that just leaves me with we've got Mr. Thompson from Production 78, but that's obviously the sound and video recording people. So that leaves me with Mr. Alderson, please. Hello, Mr. Alderson. You might need to do. Hello.
Hello. Yes.
Hello. Yes, we can hear you.
Yes, fine. Carry on.
Oh, okay. Thank you, Mr. Alderson. *6 to mute and *6 to unmute at any time.
Okay.
Great. Thank you very much. That is everybody on the attendance list that I've got. I'll just briefly do a shout out. Is there anybody else? No, the silence was what I was hoping to hear. In which case, I'll now briefly turn to some housekeeping matters. You've got the agenda that came with the joining instructions. And if at any time you lose connection, please can you try to rejoin using the join instructions that you've already got to get you this far. If you're not able to rejoin using the web address, please try using the telephone number. And if you continue to have problems, please try and contact the case team using the details again on your joining instructions. And if the worst comes to the worst and you're not able to rejoin at all, then we will be doing a recording of today's hearing, and you're at liberty to listen to that at your convenience, and then make any submissions you wish to make by the next deadline, which is deadline 11, Friday, the 3rd of July. As I've just indicated, a recording is being made of the hearing. This will be the formal record of the hearing. And if you participate in the hearing today, you do consent to being recorded. The recording unusually has been made in both video and audio modes. So if you do not wish to be videoed, for those of you who are on Teams, then please turn off your camera the camera icon is found on the toolbar. It should be somewhere towards the bottom of your screen on Teams. To ensure compliance with the general data protection regulations, please try to avoid giving out any personal information of the sort that most people would prefer to be kept private. We won't be issuing any notes of the hearing. We will be doing action points at the end of the third day, but we won't be doing any notes of the hearing, so please keep your own records as necessary. We will be sharing some documents today. That will mainly be being done by Mr. Price, and these documents will be referenced using their exam library reference numbers. Because the original plans are quite large and multi-layered, the applicant did send us in some compressed versions of the plans. They're exactly the same, they're just compressed versions. Those are the ones we'll be bringing up on the screen because they load so much more quickly than the original ones. The only downside is that they won't be as clear to view as the original plans. Mr. Gould, Mr. Price and myself will be the only people who will be sharing our screens today. Therefore, if you do want the hearing to see a document other than those that are in the agenda, please let us know at the appropriate point. We will only share documents that are listed in the exam library though. And because we haven't preloaded those documents, they might take a while to find, so please be patient with us and please try to keep the requests for additional documentation beyond those in the in the agenda. Please try and keep those to a minimum because it will take us some time to find them and load them. Okay, turning to the purpose of this morning's hearing session. This morning's session is to look at compulsory acquisition and to hear from affected persons, or APs for short. We've already got your cases, so we have heard and seen your cases already in writing, but today we'll be looking at specific issues driven by the agenda. We will be providing you with regular opportunities to speak. I think even more so in this virtual format than when we're all sat together in the room. Firstly, please give your name every time you speak, because we can't see you in your nice little groups who you're sitting with, so we don't know necessarily who you represent. So please give your name and your organisation when you speak. And secondly, please don't try and talk over each other, because it becomes really difficult for us to hear what's being said if more than one person's speaking at the same time. Please, can anybody who speaks today provide a written summary of their oral representations with any other post-hearing documentation? And that's the next deadline, which, as I've already indicated, is Friday the 3rd of July, deadline 11. Okay, before I move on to agenda item 2, are there any questions about anything I've said so far or anything on the agenda? No, I should just mention that if you did want to attract our attention at any time, most of you using Teams will see that there's a hands up, a raise your hand function on the toolbar. That's the best way of getting our attention. And once you've said your piece, please can you then lower your hand, again using the same icon on the toolbar. If there's nothing else, I shall now move over to agenda item 2, and I shall hand over to Mr. Gould, who'll be taking us through the next part of the session. Thank you, and over to you, Mr. Gould.
Thank you, Mr. Jones. This whole session is, I suppose, slightly unusual in that what we've done is combined, if you like, an overarching type issue, special land, special category land, with a specific objection, i.e. that relating to Park Barn Farm, but we decided that was probably the best way to address that. Ordinarily, doing a session like this where we've got a specific objection from a party, we'd invite that objector to make their case first and then allow the applicant respond. But we're going to flip the order and run in effect with applicant first, Surrey County Council in the middle, because you've got interest in special category land as well. And then later on, we'll come to the specific objection of Park Barn Farm before we then get to a range of questions that certainly I have got to pose. Is everybody content with what is a slightly unusual running order? I'll start with Mr. Humphries first for the applicant.
So yes, I'm perfectly content, and we've planned on that basis. And I was going to lead on your agenda item 2, and then I think Mr. Shuttleworth will play a much bigger role in agenda item 5, where you go through your various steps.
Thank you, Mr. Humphries. There is some interference. I'm not quite sure where that is. I can definitely hear a lot of interference. Can anybody else hear that?
I could, Mr. Gould. It's now gone.
I'm sorry, I think that's me. I'm so sorry. My headphone. I think Ben Garbutt, Keystone Law. I think that was me. Apologies. I need to keep my headphones on to avoid that happening. So please tell me if at any stage you.
Yeah.
It's Mr. Alderson. I had interference.
I think what we'll do is we'll carry on with the agenda, just see how things pan out. So we will start with the applicant in a minute, then we'll come to, sorry, are you content with the running order for this morning?
Thank you, Sir. David Stemford, Surrey County Council. Yes, we are happy. Thank you.
Good. Okay. And Mr. Garbutt, I presume you're content on Mr. Alderson's behalf with the running order?
Yes, I've seen the running order, and that's perfectly fine. Thank you.
Yeah, Mr. Garbutt, we are finding it very difficult to hear you. You're very, very faint.
Is that any better? Is that any better?
No, I'm afraid not.
Right.
Whereas, say, compared to yesterday, I don't know whether you've set up slightly differently. Yesterday, you were fine.
It's exactly the same, actually. I've got my headphones plugged in. My sound is turned up as well. So are you getting interference?
The interference has gone.
It's okay, Mr. Garbutt, so far. I can hear you reasonably well. You're a bit quieter, and now you've gone a bit louder, and there's no interference so far.
Right. Well, I've got the sound turned well up. So
that's good. That's very good.
Loud, I will not be able to listen through the headphones. It's quite loud for my ears. But if you can hear me now, I'll settle at that volume.
I think everybody else definitely can hear you.
Good. Thank you.
Okay. So I'd now like to turn then to the applicant to give your introduction, opening remarks on compulsory acquisition, temporary possession for special category land. And we'd like, if possible, if you can aim to do that, Mr. Humphries, within about a 10-minute slot. So that will take us to about 10:20.
Yes, thank you. So Michael Humphries for Highways England. So what I'm going to do is turn the camera off now, because it seems to me that the audio is far more important than you seeing me sitting at home, and then I'll turn it back on later when I don't need to speak. So I'll turn the camera off now, but I will continue speaking.
Yeah, that sounds fine. Thank you.
So thank you. So this is agenda item 2. I'm going to deal with our general case in relation to special category land. So the first point to make very obviously is that the scheme is located in an area of special category land, as the construction of the original M25 and A3 interchange required the taking of land from Wisley Common, Chakeley Heath and Ockham Common, and you can see the special category land on the special category land plans. That's Rep 8-006. And the plots are specifically set out on those plans, both common and open space, and they're differently coloured to distinguish between them. And also, please note that Schedule 10 to the DCO sets out in parts 1 to 3 the special category land in different categories, and part 4 is obviously the replacement land, and the total special category land requirement is set out in Table 3 of the Appendix C Commons and Open Space Land Report, and the latest version of that is Rep 8-015 on page 42. No need for you obviously to look it up at the moment. A description of the special category land affected by the scheme is set out in section 4 of that report, but also, sir, in our response to your question 3.16.9, and you should have that at Rep 7-004. That's on pages 58 and 59. So as far as replacement land is concerned, that's been provided in exchange for the special category land which is to be acquired, and in respect also for the permanent rights which impose a burden on the land. And the replacement land is at Park Barn Farm, which usually has the PBF sort of abbreviation, so PBF 1 to 3, Hatchford End HE 1 to 2, and Chakeley Farm CF 1 to 4, and they're shown on sheets 11, 12, 13, 14, 26, 27, 28, 29, and 30 of the land plans, which you've got at Rep 8003, and the land parcels are also identified in Part 4 of Schedule 10, as I mentioned before. The approach, and this is going to be, I think, one of the critical issues today, what the approach to identifying and calculating the extent of the replacement land is described in sections 2.7 and 5 of the Common Land and Open Space Report, the latest version of that. The ratios are, again, be obviously one of the issues today, 2.5 to 1 for land permanently acquired from Common, 2 to 1 for land permanently acquired from open space, 1-for-1 for rights permanently acquired along bridleway and associated works, and then nothing for rights permanently acquired for the undertaking of the initial management. This is land where there is no additional burden. And the replacement land parcels are described in section 5 in Appendix B of the Common Land and Open Space Report. And other than the owner of Park Barn Farm, none of the current owners of the replacement land object to its acquisition. And so I suspect that's why you've been able to combine both this general session with a specific objector. Highways England did consider, sir, alternative replacement land locations, and those are set out, and the consideration set out in section 5.5 of the Common Land and Open Space Report, and of course also, sir, in our representations, our responses to the representations by Park Barn Farm. And one of the sites that, so you will know there's been some discussion about, is the use of land at Pond Farm as an alternative, and this was explored by Highways England, but was discounted because the acquisition of the land for public access would so conflict with the existing use of the land as a herd management business by Surrey Wildlife Trust, who are represented obviously today, and that land we consider fulfills a wider public purpose in relation to the SPA. So our reasons for rejecting Pond Farm are set out in the Common Land and Open Space Report, particularly if you look, sir, at section 5.5.1 and in various other documents where we've responded to things. So, for example, Rep 4004 at page 12 and Rep 6014 at pages 7 to 9, sir, and I give you those just for your reference, and we can pick those up in any summary we provide. So relevant provisions then in the development consent order. The provision of replacement land is secured by Article 38. And so there's also, you need to bear in mind, I know you will be aware of this, but requirement 7 in Schedule 2. That's the design, layout and implementation of replacement land requirement, and that's in both of those in the latest version of the DCO, which you have as Rep 8013. And just to kind of summarize those very briefly, Article 38 prevents Highways England acquiring the special category land needed for construction of the scheme until it's acquired the replacement land and the details of a scheme for the implementation of that replacement land has been approved by the Secretary of State under Requirement 7. And Requirement 7 itself provides further details for the measures to be approved by the Secretary of State. And so you'll recall there's a kind of long list of things, including requirements for consultation, including with the people who are to take the replacement land. In other words, the people from whom the special category land was taken and in whom the replacement land will be vested. So they have to be consulted as well before a decision is taken on the application. And then Requirement 7.2 requires that the authorised development is carried out in accordance with the approved details. So as far as legal compliance is concerned, and Section 131 and 132, so you'll be very familiar obviously with those. Section 131 relating to the acquisition of land, the acquisition of freehold, and 132 being the equivalent provision where rights are taken over special category land. And again, you'll understand that the importance of these two provisions for a promoter, such as Highways England, are that unless they can get through one of the exceptions, then special parliamentary procedure applies, and SPP, as it's usually known, is a sort of lengthy and can be a fairly uncertain process which would delay the scheme. So we have sought to bring ourselves within the various exceptions, and so I'll just kind of set out our position in relation to those two sections. In respect of special category land subject to outright compulsory acquisition, so acquisition of the freehold, we've provided replacement land at the ratios I described, and that's to satisfy Section 131 4, and that will be vested in the prospective seller by virtue of Article 38. So the effect of the article is that once we've purchased that and satisfied the Requirement 7 condition, then that land will be vested in the replacement land will be vested in the person from whom we've taken the original land. And you can see that in the way in which Schedule 10 works with Article 38. And the replacement land meets the statutory definition of replacement land, which is in Section 131(12), and it has to be, there are kind of two important aspects. It must be not less in area than the land to which it relates, so not less. It can be more, but it can't be less, and it will have to be no less advantageous than the land that was taken. So it can be more advantageous legally, but it can't be less advantageous, and the extent to which it can be greater in land area or greater in advantage is obviously part of the kind of planning balance. In a sense, that's part of the evidence that you have before you, and that's where Park Barn Farm in particular are arguing that we shouldn't provide as much replacement land. As far as rights are concerned, so Section 132, again, there are two different aspects of this. So permanent rights over special category land, which will be burdened in some way, and these rights include rights to carry out works to implement things like kind of culverts, drainage works, earthworks, maintenance, access, utilities, apparatus, and things like that. And our view is that those are a burden, and therefore we've provided replacement land, and those are listed in table C3 to the open space, common land and open space report, and in part 2 of that schedule 10 that I talked about. So where we're taking land and we think the right does burden, that's part 2 of schedule 10. And that's the 1-to-1 ratio that I talked about before, and that gets again vested in the prospective seller by virtue of the way in which Article 38 works. And again, the definition again in Article 132.12 again talks about the replacement land is land which is adequate to compensate the following persons for disadvantages which result from the compulsory acquisition. So that's the test which we think we have satisfied. And then the third kind of category here is where we are acquiring permanent rights over special category land, but in our view that those rights don't burden the land. And the sort of rights we're talking about here are the rights where we've taken rights to carry out environmental enhancement works of one sort or another, or rights for maintenance of the NMU routes. It's that type of thing, and these are listed in plot C4 of the special land report, and in part 3 of schedule 10. So that's that list, and we haven't provided replacement land here because we say there is no disadvantage, because we say in that respect, section 132.3, that the land will not be less advantageous. So that's our broad argument in relation to all of those things. I think I'm around 10 minutes, so I'm happy to stop there and answer any questions that you may have.
Thank you, Mr. Humphreys. I mean, the 10-minute was a guide, if you like, just to keep some control. If you feel there's anything that you might have missed or you want to put, by all means do so. What we were just worried about was people running away with time. But yeah, you've kept to a good time scale. So if there's anything you feel that you might have missed, then please say now. Otherwise, I'll hand over to Surrey.
So I think that sets out the principal points really I wanted to make. There are one or two, I suppose, other things in relation, for example, to that last category. We do have an alternative argument under section 131.5, but I think my view is, rather than getting too deeply into some of the legal points, we could set that out in our summary note that we'll provide, and that will give you I think more time for the more controversial issues this morning, that where you'll want to hear from various other parties. So I'm happy for the moment that I've covered the broad spectrum of our general case, which is what you wanted.
Thank you very much, Mr. Humphreys. I think what we're also likely to do is that once we've got through agenda item 5, which is the examining authority's questions, we may well say, in effect, have you as the applicant got a final set of comments you want to make before I ask Surrey to make a final set, and then Part 1 Farm? And that might give you the opportunity to pick up anything that you think might have developed and not been covered as we've gone through the rest of the agenda up to that point. So it sounds like the applicant has concluded its initial opening. So I'll now turn to Surrey to give your opening remarks. What I would suggest, and I hope it won't be too disruptive, in your opening remarks, if you've got anything to say, particularly about the implications for the operation of the Ockenbite car park, that is, I think, possibly more of a general management type issue that might be better placed being dealt with in the session that we've got with you and the applicant this afternoon. It affects the special category land, but it sounds it's more of an operational matter as a landlord and tenant, with a tenant, rather than directly dealing with the sorts of issues that we've got in agenda item 5. So if you're content, we'll not spend too much time this morning dealing with the Ockenbites car park because we've got the opportunity to do that this afternoon. Mr. Shuttleworth, are you happy with that approach? Shuttleworth, you're muted.
Yes, I'm muted now. Yes, I'm fine with that approach.
Good. Then if you'd like to start your 10 minutes or so, which will take us to around, so I've just, well, 10:47. So that's just a guide, but yeah, please say whatever you need to, and we've got an element of latitude. Sorry, Mr. Stempfer has raised his hand. I think he might want to make a comment.
Good morning, sir. David Stempfer, Surrey County Council. Apologies, were you moving to Surrey County Council's evidence? Because if so, that would be my colleague Steve Mitchell.
Mr. Shuttleworth is Highways England.
Sorry, yeah, I've managed to bury my notes.
Slightly confused.
I can see the difficulty we seem to have with the way Teams displays things is it doesn't show everybody all the time. If somebody hasn't said anything for a while, we don't see anybody. My apologies. I need to unbury my note. Mr. Stempfer, for Surrey County Council, are you content that we in effect deal with any Ockenbites type issues later on today, i.e. this afternoon, rather than this morning?
Thank you, sir. David Stempfer, Surrey County Council. Absolutely, we're happy. We were prepared to talk about Ockenbites in this afternoon's session, so happy to leave that to this afternoon. Thank you.
Good. That might just relieve any time pressure we might get as we develop or go through this morning and get more deeply into the Park Barn Farm objection. Right, so we now do a turn to agenda item 3, and like whoever is going to present the Surrey case, to start doing that now, please.
Okay, Steve Mitchell, Surrey County Council. Good morning. Thank you for the opportunity to set out the case, the overall case for Surrey County Council's views regarding the compulsory acquisition and temporary possession of the special category land. As set out in with the Statement of Common Ground with Highways England, the County Council considers that the compulsory acquisition and temporary possession of the special category land or rights over the special category land owned by the County Council are appropriate, and that the draft DCO makes provision for replacement land, suitable provision for replacement land, should I say. The County Council has been involved in discussions with Highways England regarding the different factors affecting the council's land, and has responded in our role as both landowner and statutory body in respect to public access particularly, and also representing the best interests of our residents. Discussions relating to the replacement land have broadly covered the suitability in terms of public access and also in terms of biodiversity, along with our partners Surrey Wildlife Trust, and responses to the specific proposals for land parcels put forward to us by Highways England. The background information of the rationale and the evidence to support the decision making has been provided by Natural England. And the Council's involvement, therefore, in the process has been at a relatively high level. The County Council's 2030 vision for Surrey sets out our aims to support communities in a range of different ways, with the protection and enhancement of our natural and accessible green space being a key element of that. We're of the view that the replacement land set out in the scheme would make a valuable contribution to those aims. And the replacement land in the northwest quadrant of Park Barn Farm in particular provides a favourable location due to its proximity to the existing accessible land, and also particularly the residential area of Byfleet, which is in close walking distance. And finally, it's the council's expectation that the title of all land to be transferred to the council will have undergone a due diligence process to ensure that it's been transferred unencumbered by any potential issues such as outstanding covenants, enforcement notices, or adverse title. So thank you. That's the council's case for agenda item 3. I think that was a bit less than 10 minutes. Thank you.
Mr. Mitchell, that was very succinct and definitely within 10 minutes. So we're grateful to that that approach. Mr. Garbett, are you ready to make your submission under agenda item 4?
Yes, sir, I am. I shall try not to claw back the time you saved as well whilst doing so.
You are a little faint.
Am I again?
You're much better than you were at the very start.
Right.
Well, can I put it another way? Is there anybody who can't hear Mr. Garbett well enough to follow him?
I'll speak again whilst you've asked that question.
So can I, Mr. Garbett, just excuse me for a moment. Can I just, it's Michael Humphreys for Highways England. I thought, but I may have misunderstood, that you wanted to deal with Surrey first and then look to see if we had anything in response to what Surrey had said. I had a very small point I was going to make, but I may have misunderstood how you wanted to deal with it.
Mr. Humphreys, a slight misunderstanding, but I think if it's a brief point, it's worth doing it now. Otherwise, we might forget it later on. And I don't think that will necessarily disadvantage either Surrey or, for that matter, Mr. Garbett for Part 1 Farm. So, yes, please, Mr. Humphreys, make your point, and then we'll do another test with Mr. Garbett to see whether or not everybody can hear him. But, yeah. Mr. Humphreys.
It was the very last point that Mr. Stemfer very properly made about due diligence and covenants and title and so on. And I was just going to draw your attention to the fact, sir, that obviously one of the effects of the order, and in particular Article 38, is that when we acquire the special category land, it itself is cleared, if I can put it like this, of all rights and so on. When we acquire the replacement land, that is cleared of rights, but it is then burdened with all the rights, trusts and incidents to which the original special category land was subject. And we can take that, in a sense, offline and discuss that with Mr. Stemfer, but it's important that we kind of understand that the land given to the county and other parties isn't kind of unencumbered of anything. It has the same encumbrances as the land that we took from them. That was all I wanted to mention, and we can discuss that with the county offline.
Thank you, Mr. Humphreys. Yeah, I certainly took Mr. Mitchell's comment to mean that, in fact, what the county council were doing, in effect doing, if you like, clean title type checks to make sure that there was nothing nasty going to come out the woodwork that really affected what was going on, to enable the transfer to take place ultimately of the replacement land, whatever the replacement land amount might be, presuming an order, of course, is made.
Thank you, and apologies to Mr. Mitchell. I again, not seeing people on the screen, thought it was Mr. Stemfer, but Mr. Mitchell then, if Mr. Mitchell made those points.
Mr. Garbett, are you ready?
I am, sir. Thank you very much.
And you're sounding
ready
very
to
good
go.
at the moment.
Good. Well, I've turned it right up, so that's fine whilst nobody else is talking. So I shall stick with that, and also switch off the video as well, in case that does improve things yet further. So if you're ready, I think a good place for me to start actually would be to give a brief overview of the Park Barn Farm site and to say something about why the orderland, and by that I mean the orderland which is affecting Park Barn Farm, holds particular importance to the objector. All this is actually set out in evidence, sir. There are two statutory declarations which you can find at Rep 1-035 and Rep 5A-013. So to reach Park Barn Farm, one has to take a winding drive down through ancient and mature woodland, and then one arrives at the place of 3 dwellings where Mr. Alderson and his family all live. And really, if you make that journey, the first thing you'll notice is what a peaceful and secluded spot it is. It's very much shielded from the sound of road traffic, from the natural contours of the land and the surrounding tree belt. Now, the orderland will take away almost half of the land, that is 50 acres, which is part of the domestic curtilage of those dwellings. Not only that, the land which is being proposed to be acquired is some of the most highly prized land within fields PBF2 and PBF3. Now, this land has very special qualities in terms of its visual character, its natural beauty, its wildlife, and it also contains other man-made features such as 2 ponds, and it's overlooked by a summer house, and there's also a pole barn further down the field. The objector and his family have used the summer house and the pole barn for hosting various private parties and events over many years. So confirmation of the order would have a significant impact on what is an attractive and well-used part of the domestic curtilage, land which contributes in a meaningful way to the amenity and valuable enjoyment of those 3 properties. And I would finally add on this point that the blight which the scheme is causing is adding some personal distress at a time when the objector, Mr. Alderson, has been seriously unwell and had been trying to sell the property, all of which is not possible at the moment. So next, really, I want to come on to what I would call a summary of the reasons why the order should, we say, not be confirmed. So with that in mind, I would start by saying that I think on any fair, objective and rational assessment of the evidence, it really must be concluded that the part of the orderland to be acquired does not really offer much by way of current advantage. And when I talk about advantage, what I'm saying really there is advantage measured in terms of its recreational use, not only by members of the public in general, but other persons who actually use the special category land. And that is because whilst some parts of the orderland may be visually attractive, it is still not particularly usable due to undergrowth and due to the sort of physical impediments one sees when trying to make journeys around the road junctions. Nor, in fact, is the land particularly well used. And I think to add to that point, the user experience, such as it is also very badly impaired by the sight and sound of road traffic. So we say there would be no serious loss of advantage caused by the acquisition of that land, and that includes no serious disadvantage in terms of permanent rights taken over other parts of the orderland, certainly not to justify a one-for-one swap, which is what the applicant has suggested. And we'll turn later, I think, to the 2 definitions where you'll see there is a difference in terms of the requirements in that regard. One is only required to show that there is something which is given which offers adequate compensation for the land affected by the order rights. And to add to that point, we will talk about the historic schemes, but none of those schemes actually gave compensation for order rights. The land switch was purely in relation to land taken. So that's on one side of the coin. And on the other, the replacement land parcels, that, well, really they've been selected because they do, on a scheme-wide basis, provide much of a like-for-like replacement in terms of visual and landscape character. And there are a couple of references there, which I can give you. Statement of Reasons 7.2.7 and Appendix C 2.7.4, both of which are relevant to that issue. Added to which, there is some proposed planting which will only improve the recreational amenity value provided by that replacement land. And I think, again, looking at this from a scheme-wide basis, we can say that in general terms, at least, much of that replacement land shares the same general characteristics and advantages in that they are located close to the affected order land. They are available for use and will generally be accessible by members of the public. These land parcels are mostly contiguous with other existing blocks of special category land, and so they will help to create larger usable areas of access land. Moreover, they are well connected to the rights of way network, and they will benefit from further scheme enhancements in that regard. Again, a reference, Appendix C of the Common Land and Open Space Report, paragraph 3.4.17. Those parcels are also uniformly much quieter than the order land, being much further away from road traffic, and they of course are less visually impacted by road traffic and the associated assorted road infrastructure. So those are the two sides of the coin, and then really, if balancing out those relative advantages sensibly, we say it can really only be concluded that replacement land is more advantageous as a whole, and that at any rate a ratio of almost 3 times the amount of special category land that would be lost is totally disproportionate and far more than is actually necessary to achieve equality advantage. And I would add that if one looks more closely through the documents, it will be seen that the applicant has not carried out a proper human rights balance at all. And in any event, Park Barn Farm, insofar as it has been taken into account, has been treated as agricultural land, not for the fact that it would impair the use of 3 dwellings. So in my submission, compulsory acquisition on this scale would constitute a wholly unjustified interference with the objector's human rights and those of his family. And it also fails to satisfy the Basic Planning Act requirement for a compelling case in the public interest. Now, those are quintessentially matters of judgment, but in my view, it is relatively simple and straightforward to conclude that the 2 statutory definitions of replacement land are satisfied, even if the overall amount of replacement land is reduced by nearly 2/3. The sheer weight of evidence really indicates that whichever replacement land parcels are chosen, the appropriate ratio should be close to 1-for-1 equivalence for the loss of land, with perhaps just a small incremental addition to compensate for the acquisition of permanent rights. So it follows from that really that one has to make some hard choices now about which replacement land areas should be selected to make up this reduced total. And since compulsory acquisition of the land at Park Barn Farm requires a special human rights justification, which is currently lacking, because it would obviously affect the ordinary use and enjoyment of those dwellings, one should steer away from that site where we've heard the other replacement land parcels have not attracted any objections, and those parcels are all in agricultural use. So it is absolutely critical to avoid Park Barn Farm, but I do recognise that there are preferences that have been expressed, and so I would add that if any part of Park Barn Farm should need to be taken, then that acquisition should be limited to the cow field, which is the field otherwise known as PBF1. Since that part of the land is less intimately associated with the curtilage uses I've described, it does though offer substantial advantages in terms of public recreational use, being contiguous with existing common land and open space, and is also well connected to the rights of way network. So I'm nearly done, but I just wanted to add a few words about the previous road schemes, because of course the approach taken by the applicant is to apply target ratios, and really they are simply not a material consideration here, and the fact that the applicant has been really so wedded to those target ratios and in the final reckoning has actually exceeded them by a distance, we say discloses a serious error of approach, and moreover it will be hard to rectify that error given the sheer chasm between what it should have done and what it has actually done. So just to conclude, I did also have something I mentioned yesterday was a short presentation, if you like, of the ways in which we say the statutory test should operate in practice. Now, I think some of this will come out as we go through the questions which you've set in agenda item 5, or indeed they could be these points could be set out at the end in my reply. But if there was more time, then I'm very happy to do that now.
Thank you, Mr. Gov. I think I'd actually like to hold that last point over, potentially once we've been through the questions, because it might well be that it's actually something that's better for written submission anyway. I think Mr. Jones and I both understand definitely the argument you're making and how it sits within the legislation. I think a lot of what we're going to do later this morning is more about the mechanics of how you get from the affected special category land through to just how much replacement land is required, and then where that replacement land might end up, which are really the 4 steps in Agenda 5 that we've set out. And it's fair to say there are a fair number of questions that lie behind those 4 steps, which potentially will get us from, well, I was going to say A to B, but I suppose if 4 steps, it should be A to D. But there is one question I'd like to put to you now, Mr. Garbett, just so there's no uncertainty, because I've made a note, and I think we need to clarify it now. So I'm just trying to find. Mr. Garrett, you commented that the order should not be confirmed. Now, I took that to mean, when I heard it, that the order shouldn't be confirmed lock, stock and barrel. Were you perhaps meaning to say that the order with all of the replacement land identified such as it is at the moment should not be confirmed, i.e., as I alluded to yesterday, if we look at paragraph 16 in the guidance, there are a range of options available to the Secretary of State depending on his consideration of the report that's made to him, i.e. that he can, if he's minded to make an order, He confirms the order in effect as submitted with all of the replacement land, option 1. He could make an order with no replacement land, option 2, or option 3, there's something in the middle. Now your reference to order should not be confirmed, is that closer to option 3 than option, whichever I said, with no replacement land, or sorry, no compulsory acquisition of any land, because that's how it seemed to come across.
Sir, to respond to that, yes, you've alighted upon a point which I can clarify. I certainly wasn't intending to suggest that the order could not be confirmed with any amount of replacement land. I think the issue is how much land is enough, if I can put it like that. And there are a range of options which have been put forward. But I think, I think it depends on how one looks at that evidence. These are matters of judgment, but there must always be sufficient evidence to make a rational judgment. So I would say it depends. And if you take the case that we've put forward, then one has to make a radical jump from where we are now to get anywhere close to what we think is a rational judgment of the available evidence, something close, as I said, to the 1-for-1 ratio. So yes, I think I think in the final reckoning, if a balanced and fair decision is taken, and it is supported with evidence, then I think there is a middle ground which enables the order to be confirmed. But certainly in its current form, I would argue that that is not possible.
Thank you, Mr. Gower. I just thought we should get some clarity on that point at this stage before we go much further. I'm conscious the time is
just one more question, if I can interject, Mr. Gould. It's along similar lines, but just so we're absolutely crystal clear, Mr. Garbutt, is it your case that you're objecting to all 3 parcels because you did kind of allude to the fact that if one of them had to go, then it would be PBF1? But is it your case that in terms of your objection is to any of the parcels being used for replacement land?
Yes, sir, to respond to that, I would answer it like this, which is that one needs to make a choice according to a range of possible options at this stage. And some of those options could discount any land from Park Barn Farm entirely, or to exclude that site entirely. In other words, it would be perfectly lawful, reasonable on the evidence to select replacement land in the other quadrants which service the need for replacement land in its entirety. So I think the logical extension of our objection is that you just do not need Park Barn Farm at all. There is sufficient land to make up the kind of ratio that we're talking about elsewhere in the scheme. And also because there are particular issues associated with interfering with private residential interest, one should certainly be steering towards those options when the planning balance is being made. But I suppose I was being pragmatic in the sense my client is to be congratulated really in trying to I think shift the goalpost slightly, and he was able to indicate, which we have done in the objections, that the cow field was really the least important part of his land holding. It's the one that causes least interference with the use and enjoyment of his property. So if you were minded or hell bent on pursuing an option which wanted to include land in the north western quadrant, then we would say it really should be directed towards that parcel of land, because it is, for all the reasons I've explained, it's well connected and it's suitable and available for public recreational use. So I've sort of gone on there a bit, but if that answers your question, sir, I'll leave it there.
Yes, it does. Thank you, Mr. Goddard. I just wanted to make sure that we were crystal clear on what you were saying. Thank you. I have no further questions, Mr. Gould.
Right, sorry, we've gone a little bit beyond 11. I think this might be a convenient time to take a short adjournment on the basis that yesterday we were working on the basis of about an hour sitting time, being comfortable. And that would mean that potentially we resume, if we say 11:15, is everybody content with that? I'll put a general, is anybody not content, and can they please show?
So can I just raise one thing? Again, I don't know whether you, Mr. Humphreys, sorry, for Highways England, I don't know whether you would want us to briefly respond. Clearly there's a bigger discussion around these issues, and that will probably emerge during agenda item 5, but I could very briefly just make 5 points, I think, in relation to what has been said, which would give our position. That would also give Mr. Garbutt then an opportunity to have reflected on those things before we go to the next to the next agenda items, but I'm entirely in your hands.
Mr. Humphreys, how long do you think that might take? Because it could either be done now or it could be done immediately after we adjourn for a short period.
I would think 2, 3, 4 minutes, but
I think we'll crack on with that now. Then I think that's appropriate.
Okay. So I'll turn the, well, if you're hearing me with camera and audio, I'll kind of stick with it because this is going to be short. First point I'd make is this: it is important to understand, as Mr. Garbutt very correctly acknowledged, that the landowner here has been trying to sell the land. So this is not one of those cases where it said there's an interference with domestic property and the landowner does not want to sell. The landowner does want to sell. Indeed, as part of this first point, the landowner has served a blight notice, a statutory blight notice on Highways England, requiring us to purchase not just the PBF 1, 2 and 3 plots, but all the other land as well, claiming material detriment. And so, this is a case where the landowner actually not just doesn't object to purchase of the farm, but wants us to purchase all the farm. Second point, just which relates to the first point, is in relation to that, it is fair to say that Highways England has served what's called a counter notice, saying that it shouldn't have to buy all of the land. It should only have to buy that part of the land that it wants. And that matter is going to the Lands Chamber to be heard, I think, later this year. I'm not involved in that. But the important point to bear in mind from these first 2 points that I make is that, in effect, what this amounts to is an objection which is focused around compensation. It's to do with how should the landowner be compensated for us taking either all of the land or part of the land, and them having having, it would be alleged, a material effect on the value of the retained land. Third point, and this was a point Mr. Garbutt very properly made 2 or 3 times, once early on, once in the middle, and once slightly differently towards the end. He made the point that, well, the only rational objective judgment that could be made here is that not all the replacement land is needed. Or in another place, he said, well, one can only conclude that the replacement land is more advantageous than required, or later that, again, talking about rational judgment. You will listen to it on the tape. I won't have captured absolutely the context, and forgive me, Mr. Garbutt, if I've slightly got it, but an argument really about the evidence leading to only one rational conclusion. We very strongly disagree with that. There clearly is an issue here on the ratios of replacement land, and it is ratios because Mr. Garbutt correctly reflects that there should be some replacement land for that land loss. There is a dispute about the ratios, and we would say Mr. Shuttleworth, who clearly has worked in this field and has expertise and is giving expert evidence, and the county, who have officers with relevant expertise, believe that the ratios we've put forward are adequate. I think Surrey County Council said that the land was suitable and appropriate, and it's very properly our view that that is right. Now, we recognise that the Secretary of State may disagree with us, of course, but if the Secretary of State agreed with us, that is not irrational. It is not irrational or in some way unreasonable for the Secretary of State to accept the evidence of Mr. Shuttleworth and Surrey County Council. The fourth point, I think it was suggested, and this is well rehearsed in the various exchanges between ourselves and Parbarn Farm, it's wrong to suggest that we're in some way wedded to target ratios. We have looked at previous experience, but we have departed from that. The special category land report explains what we have done. And the fifth point, very briefly, I'm grateful to Mr. Garbutt again for clarifying that he's not suggesting that the order as a whole should be refused, or that no special category, no replacement land should be acquired, that this comes down to a question of ratios and the appropriateness, and also for indicating their preference as to which land, if any of the land is taken, which part of their land, and that I think again comes up perhaps under agenda item 5. So those were my 5 points.
Thank you, Mr. Humphries. Mr. Garbutt, I'm not going to ask you to respond to any of those matters now, because that may well be something that you want to come back to when you get the final right of say, once we get through agenda item 5. We are now virtually on 11:15. What I'm going to suggest, and again, we'll take it that everybody agrees unless somebody says otherwise, is that we adjourn now until 11:30, which will be slightly over 10 minutes. If nothing else, give me the opportunity to get some of my papers in order for what might be a bit of a dash through a set of questions. What I would say for the next session, just so everybody's aware, I do have a, if you like, a set agenda of questions. I'm going to be quite, if you like, brutal about keeping on track with those questions, rather than letting too many people, if you like, go down avenues that will take us off the course that I've plotted. Because I think if we go off that course, we may end up spending more time and go down avenues that we don't necessarily need to go down. So without any further ado, this session is now adjourned until 11:30.
Okay, good morning, everybody. It's now 11:30 by my reckoning, and time to resume. I'll just wait for you all to gradually arrive before I hand back to Mr. Gould. The one thing I would say is now we are probably going to enter the most document-heavy part of the sessions, in which case there'll be some sharing of documents. And this does run the risk of screen flicker. And I didn't mention this morning, I have mentioned previously, if anybody is sensitive to moving images, is flickering images, then now is the time to look away, because there is every chance that once we get a few documents up, there could well be some flickering of them. So it's just one of the joys of the technology, I'm afraid. So with that caveat in place, I shall hand back to Mr. Gould.
Thank you, Mr. Jones. Can I just check, as I understand it, Mr. Shuttleworth is probably going to do a lot of this session. Mr. Shuttleworth, do you have access to documents either in a hard copy or on another screen other than that you're using your Teams link with? The reason I asked the question is just in case we do get to screen flicker, and we're literally having to possibly go through audio only, or a participant has to go to audio only, that we can still navigate our way through the documents by describing things to one another. So, Mr. Shuttle, have you got alternative documents available to you other than going through screen share?
Yes, Andrew Shuttleworth, How's England. Yes, I've preloaded a brace of documents that have not all the documents listed on the agenda and on Mr. Garbutt's submission, but a lot of those documents I've preloaded on the grounds that we may have to refer to them, or at least I may have to refer to them in trying to.
That's just useful to know. Then I know that if we have got a problem, the applicant is still likely to be able to operate without screen share. For Surrey County Council, any idea who from your team is likely to be participating in this session?
Thank you, sir. David Stent for Surrey County Council. Perhaps if you were to turn to my colleague Steve Mitchell in the first instance.
Yeah.
Steve, if you're happy then to cascade in. Thank you.
Thank you, Mr.
Yes.
Stemper. Mr.
Yes,
Mitchell,
happy.
yeah, Mr. Mitchell, how are you placed in terms of documentation? Have you got hard copy stuff on an alternative screen, or are you dependent on screen sharing through Teams?
I'm fairly dependent on screen sharing through Teams, I'm afraid.
Okay, that's just helpful to know, because if you, for any reason, do have to shut down, it's just that the rest of us will have to try and describe things to you the best that we can.
Yes, understood.
Now turning to Mr. Garbutt, how are you placed?
Yes, that should all be fine with me, but I shall obviously let you know if I do have any issues.
Yeah, and Mr. Alderson, are you trying to follow documents in the background, or are you just literally listening?
He may not have rejoined, although I did just chat to him, so I think Mr. Alderson is there.
Mr. Garbutt, do you know what Mr. Alderson's setup might be in terms of documents?
Well, I suspect he's not going to have the facility to follow. He certainly was only following the audio this morning, so but you know, obviously I'm here to represent him, yeah. So I don't see an issue.
No, it's just that this can get quite violent as an effect. And really, if anybody on the call encounters it, you need literally to shout out to Mr. Price, and he will shut down, and then we'll try and recover the situation. We have encountered some quite extreme episodes when we've been testing, and it seems to be that once we get 5 or 6 documents into the system, that's when it can become quite fragile. Okay, then I'd really like to look at agenda item 5A, which is step 1, as we've called it in the agenda. And this is really just looking at the consideration of the special category land that would be affected by the proposed development. And my first question is just really to get confirmation that in terms of the special category land subject to proposed outright compulsory acquisition, what is the figure in totality? So I'm looking at really Mr. Shuttleworth just to confirm. I've got a figure in mind, but I just would like you to confirm it before I share the number that I've got, which may or may not agree with your number.
So that one is probably one that I can cover. The figure, I mean, there are different figures depending what plots you include. So there's a figure which is 129,373 square meters, but then there is a small plot called 28/2, which is being acquired to avoid severance, and if you add that, you get to 129,868 of outright compulsory purchase. And I think all of these figures are in a combination of the open space report, the revision 2 version at Rep 8015, Appendix C, Table C1 and Table C4, and also in our response to your question 3.16.3, Rep 7004, page 54 and 55. There's also another plot, I have to say, plot 2/13. That's in the Wisley lane diversion. It's it's sort of green, so it's to be used, temporarily used, because it's Surrey land, but it's being used to provide the Wisley lane diversion. And then once we've occupied it, it will go back to Surrey, obviously, because it's temporary possession, but it's been treated as equivalent to outright acquisition. The reason we're not acquiring it is because it's already Surrey's land, and it will go back to Surrey because the Wisley lane diversion is a county council road. And you could if you added that plot, you would get to 137,679 square meters. And I can tell you, I can give you the breakdown if you want between common land and open space. I've got that figure.
No, that's fine. The figure that I was expecting you to come to was in effect I've got it down as hectares. It's around 13.7 hectares. I think it's going to be very helpful to get that noted in your notes of this session, because that figure doesn't actually appear anywhere, if I recall, as, if you like, the starting point for the running of the ratios.
Yes, sir. Absolutely right. You probably have 13.77 hectares. That is, of course, 137,679 square meters. The 13.77 is just rounded to hectares rather than meters.
Now, as I say, I think it's important that we get that figure, because there are various different tables, and depending on which numbers you pull together. And I would say that inspectors are discouraged by the inspectorate to do any maths, just in case we get it wrong. And therefore, we always try and put the onus on the parties to do the maths for us.
Well, Well, so
It's
I
not that you
think
can't do it, but there have been occasions when it hasn't quite gone right.
so. I suspect that the Bar Council has much the same view about barristers and maths. So we'll leave it to people that know better about these things.
Mr. Garbett, does that figure sound about right to no doubt the maths that you've been doing at some stage in the background?
Yes, it does accord with the figure I've been looking at. I would share your view, though, about the need to produce some clear figures, because I think I've been hopping around various documents and it does get quite confusing. So if that was provided as a separate note or something, I would be very happy. But yes, 13.77.
That will definitely be an action. Okay.
That will be.
Right. That was the clarification I was seeking as a starting point. And then I think we move now to look at some functional quality type issues for the special category land that is subject to outright compulsory acquisition. And really, we're going to think about visual quality type matters, exposure to road noise. So what I'm going to ask Mr. Price to do is if you can please share in document Rep 8-15, section 4.7, which is at pages 59 to 60. And this addresses a survey that the applicant did in September 2017. Excellent, text up. There's a commentary there about results that came from the survey and a series of bullet points. Yeah, if you can keep on going. Yeah, 4.76. So we see there that the majority of the users of the special category land come by car, with some visitation by foot and bicycle and on horseback. And then in a third bullet point, we see that users often valued the quietness and wilderness, the attractive trees and open. Yeah, thank you, Mr. Price. I'll start reading bullet point 3 again. This is the response to the question. Users of the open, sorry, users, often valued the quietness and wilderness, the attractiveness or the attractive trees and open spaces, the convenient access, the lack of other users, being dry underfoot, and the ability to allow dogs to roam. So those seem to be key attributes in terms of user experience. Having got those key attributes hopefully in mind, what I'd now like Mr. Price to do is to turn to the special category land plots, the land plans. Particularly, we're going to look at land plots 4/39, 4/87, 5/5, and 5/20, which are all around sheets 4 and 5. And they're all in and around junction 10 of the motorway. If you can go on, please, I think one more sheet. Excellent. Right, I'm now going to take control of the cursor. And if I've got it right, this is plot 439. That is the buff color is 487, and it goes further down onto the next sheet in that direction. This is plot 5.5. And that is plot 520. So really we're looking at the four corners of junction 10. And I'm just going to use these plots, if you like, as a proxy for the point. I want to try and avoid moving around too many sheets, because again, the more we move around, the more likely we are to get some document instability. But if people are content that we know what we're talking about in the basic plot, so it's really the four plots on the corners of the junction. I'm now going to ask Mr. Price if he can bring up the noise figures. So if we can have a look quickly at figures 6, 7 and 6, 8 in APP 066. And what these are showing, so there's the middle of the junction, the noise condition without the scheme, and then the next sheet down, please, if I remember rightly. Yeah, if I remember correctly, this sheet shows the situation in opening year. And essentially the difference between the two plots, actually in this area, the noise climate doesn't change very much. I think, Mr. Price, if you can go back to the special category land plan, so that's Rep 8006 again, please. Can I just check that, because I'm now going to ask some specific questions about sort of, if you like, functional quality type considerations for users of the special category land. Does everybody understand the sort of context that I've tried to create, which is we're looking at a specific area, we're looking at the, in fact, the attractors of users to the special category land, and we've also had a quick dip into the noise climate as it is at the moment, and the noise climate in this particular area as it would be post-development, which actually doesn't look to change all that much from the prevailing situation. So is there anybody not sure about that context? I'll ask Mr. Shuttleworth first. Are you content with the context?
Yes, as far as I'm just trying to discern where the questions are going.
Yeah,
I guess.
I mean,
yes,
if anything becomes unclear as the questions develop, then you'll need to ask me, and we'll go back to various drawings and or documents and hopefully make it a bit clearer. Mr. Mitchell, are you generally content with the context? For us?
Yes.
Yeah.
Yeah, I understand the principle of where it's
we might be going.
Yeah.
And Mr. Garber, are you similarly?
All, yeah, perfectly clear to me. Thank you.
Good. OK. Now, what I would also say is a storm has just developed in the background at my end. There is a bit of thunder and lightning around. It may not be coming across, but of course, I might experience a short power cut, and that will take me out of the internet, which might make life a little bit interesting in a minute. So if I do go down, it's because I've literally lost power. And we'll have to try and come back via a tethered mobile phone, which might take a minute or two. So at that point, Mr. Jones might have to take control and decide about what sort of adjournment we might need. Right, so the first question in this short series really is, would those plots that we've just been talking about in and around junction 10, these four that circle it, as an example, be ones that would, if you like, fall into the category that would be most used by special category land users? So looking at Mr. Shuttleworth first, yes or no is perfectly adequate. if you want to go beyond yes, no with a bit of explanation, that's fine.
It's fair to say that as they stand, they wouldn't be amongst the plots most used by special category land users, but there are, for example, plot 5.5 has bridleway 12 that crosses it. So that part of the plot is well used by, I mean, obviously they cross that part of the plot. People are aware of the conditions of that part of the plot, which is relatively open, recently managed deciduous woodland. The plot 487 from recollection is mostly coniferous plantation. It's close to the tumulus at Cockrow Hill, so people will be aware of that as part of the buffer to the motorway. In fact, all these plots in most people's perception would be part of the buffer of the woodlands retained alongside the major roads. So their role in terms of people's enjoyment of the open access areas is principally that they provide part of that buffering to the larger areas within where the clear areas and places where more paths run. Again, bridleway 12 crosses the end also of plot 520 on the other side of the A3. And that's again largely birch or deciduous woodland. So there are plots that are relatively easy to move through, and I say part of people's perception, actually plot 439, there's a horse track there along which we've routed the proposed bridleway more or less, which impinges on the edge of that plot. So they're all plots that they will be either partly used by people using the wider areas, or at least will be certainly frequently perceived by them as part of these wider areas of public access land.
Thank you, Mr. Shuttleworth. Turning to Mr. Mitchell, what are your views on, if you like, the functional quality of those parcels in terms of, you know, are they most used, or as Mr. Mitchell has indicated, that they're possibly come into a category where they get you from A to B rather than being plots where a user might spend a lot of time having a picnic or letting their dog run free. So, Mr. Mitchell.
Yeah, I would agree with Mr. Shuttleworth's assessment of those sites. That's compatible with my knowledge of them in that they're broadly accessible. They're woodland, mixed woodland, scrub, so people are able to use them should they want to. Not particularly desirable due to their proximity to the roads, littering, noise, and as you mentioned, there are there's a public right-of-way, certainly. Apologies, I can't see the reference number on the screen, but on the right-hand side, the two quadrants on the right, there is public rights-of-way that cross them, so there is a certain amount of public access there. But I think they're essentially people travelling through those zones rather than to them or to enjoy them. So yes, relatively lower value, if you like, in terms of public enjoyment and amenity, I would say.
You need to put your microphone on, Mr. Gould, if you're speaking.
Right. Mr. Garbutt, turning to yourself on your client's behalf, same question, views on the general functional quality of these four plots, just as an example.
Yes, sir. I think we've heard the view that these aren't particularly attractive or useful pieces of land. They clearly do have a connection with the wider commons, but I think the point has been made that they are only partly used, I think was the phrase used, and not particularly desirable, was how Mr. Mitchell put it. And he mentioned things like noise and littering. So it does accord with the views we've presented as part of the objection. And I would just also give you a reference to the Statement of Reasons Appendix C. I would quote the document number, I think it's Rep 8-015. I think that's the one. I'll just confirm that. Yes, 8-015 at paragraph 2.7.11, where the applicant is making the case really for us that if it says there, if the well, it says it could be argued, I'll read it, that much of the special category land required for the scheme is close to existing busy roads and therefore not to the best parts of such land in terms of advantage to the public. This could then enable the ratio of the replacement land to be lower if it is set further away from traffic disturbance. So I think what we've heard is, goes hand in glove with the points we've made, and I've heard nothing different from those giving expert views. Thank you.
Thank you, Mr. Garbett.
We've got a hand up, Mr. Gould. Mr. Mitchell's got his hand up.
Mr. Mitchell.
Yes, thank you. I just wanted to add a final brief point in terms of the value of those sites, in that I think they perform, as may have been mentioned already, a valuable role as a buffer, effectively. And when they will be taken out, effectively, then that buffer will effectively move back, and the next area of the common will become that buffer. So whilst in their present form, they don't have a value in terms of public amenity, they do still perform a function in that respect.
Thank you, Mr. Mitchell. Now I'd like to look specifically at disadvantage that users of these plots, again as an example, might experience as further to the implementation of the scheme. So really, how disadvantaged would users of the special category land be by the loss or the permanent acquisition of these particular plots? A little bit of what's just been said in the preceding question sort of overlaps, but really what I'm trying to get to is there a limited amount of disadvantage, something more significant, or very significant disadvantage? So again, starting with Mr. Shuttleworth.
Thank you, Andrew Shuttleworth, House England. Well, the starting point was the one that Steve Mitchell interjected on in the previous question. The fact that the principal disadvantage of taking out substantial lengths of these buffer zones, particularly as most of them are wooded, is that their role is lost from the larger areas, and whatever land is therefore further into those larger areas takes on that buffer role. And the extent of what users might regard as the sort of core areas that they do frequent, being further from the roads and quieter and less visually influenced by the presence of the roads, then those core areas are in effect reduced by a similar degree to the loss of land. And the perception in some cases of extensive areas of attractive woodland. As the user survey says, a lot of users appreciate the quality of the woodlands on this site. Those perceptions of extensive woodlands in some cases will be reduced as well. There are, as you mentioned, some paths that cross these areas in other parts, particularly between Junction 10 and Clearmount Bridge to the west alongside M25. There are paths that run through these buffer areas, and a lot of these paths will need to be redirected or replaced by other routes. And clearly, from people using other parts of the scheme, there's a corollary of reducing the buffer zones is that there's in some places increased perception of the enlarged road network and its associated facilities such as balancing ponds and the like encroaching further into the special quality land, particularly around Junction 10 and up near Clearmount Bridge. And then in some places also near Clearmount Bridge, near Cockrow Bridge, and in the south part of Wisley Common down below Elm Corner, there's loss of some particularly attractive areas of woodland with large mature oaks, which have their own attractions and their own value. And also, again, the very southernmost part of Wisley Common, there'll be a degree of perception that that's to a certain degree separated from the rest of the common by the realigned Wisley Lane coming across the A3. So those would be the principal issues that acquiring these various chunks of special quality land, special category land would have for the users. Are you on mute, Mr. Gould?
Mr. Gould, your microphone's on mute.
Yeah, sorry, I'm going to come back to this point of, if you like, the scale of significance from minimal at one end to very significant at the other. And if I just use an example, we'll stay on this map or this sheet, but it's not entirely clear because really, I think, as I understand it, when the M25 was first built, basically where the cursor or the arrow is now, that was part of the common land. The old common land would have been part of Wisley Common, or would have been open space. Now, in terms of the effect on the special category land then, i.e. when the motorway was first built, would the loss of, say, this area be at a higher order of magnitude than some loss of land, say, down in this area, in terms of the current situation and the effects of the proposed development, i.e. that subject to the submitted NSIP application? Mr. Mitchell.
Steve Mitchell, Surrey County Council. I think, as Mr. Shuttleworth mentioned, there's different.
Sorry, Mr. Mitchell. I meant to ask that question to Mr. Shuttleworth. That's my mistake.
Sorry.
No problem. Mr. Shuttleworth, Highways England. Yes, I think it's a fair point to say that the area you indicated stretching up the screen, as it were, northwestwards across what would then have been a continuous stretch of Wisley Common would have had a more significant adverse impact on the usability of the common than would the areas closer to what was then the A3 dual carriageway in the area of what is now Junction 10 roundabout, in that they, in effect, created a new line of severance across the common. The only real equivalents we have of that in our proposal are the new alignment for Wisley Lane across the southern part of the common, and some people have commented that the areas of offline non-motorised non-motorised user routes or bridleways, where we set those away from the edges of the common and open space land. So in some people's eyes, those also have a severing effect, but clearly not to the same degree as would a 6-lane motorway.
Thank you, Mr. Shuttleworth. Turning to Mr. Mitchell, sorry, I'm scrabbling because actually it's getting quite dark at my end. I'm just literally going to get up, put a light on and come back because it's gone steely grey outside. That's much better. I can actually see what I'm trying to write and my notes of who I've got speaking to this item. Mr. Shuttleworth. Apologies, Mr. Mitchell, I should be asking on Surrey's behalf. Sorry, would it be easy if I put my camera on? I don't know whether that affects the quality or not, but no problem. I wouldn't have anything to add really beyond what Andrew Shuttleworth said, and I would agree about the relative values of those two different types of land that we've just heard about. So I would agree entirely with that. Thank you, Mr. Mitchell. Turning to Mr. Garbett.
Sir, thank you. I think we all agree really in terms of the difference, in terms of the historic severance. But I think there's another issue here, which is that the road schemes, when first constructed, brought the sight and sound of traffic through the commons for the very first time. And that, of course, had a very major impact on the usability of the land and also the user experience generally in the vicinity. So when one was looking at that balance in terms of impact, current advantage, sorry, I'm just going to stop there because I seem to have got somebody with a power tool outside. So if you can hear it, I apologise, but it's really quite disturbing to me. Are you hearing me loud and clear?
We're hearing you. Well, I certainly am. It's certainly not too disturbing to us, but I can well appreciate, because I encountered the same thing yesterday.
Yes, I was looking and I thought he might have finished, but no, he's carrying on, but I'll persist. The point I was making really is that it's the scale of impact is not just about the severance, but it's the fact that there were very major impacts obviously caused to the peaceful seclusion of this area generally. And that, of course, is carried through in some of the remarks we've seen about the importance of noise in terms of that being an issue which has a serious detrimental impact on the recreational user experience. So that's really where I would probably add in terms of, the differences historically. Thank you.
Thank you, Mr. Garbett. I think it's only fair that I ask Mr. Shuttleworth and or Mr. Mitchell to make a comment about noise, or do you both accept that historically, when the M25 or prior to the M25, that there was a quieter environment than there is today, and therefore again historically that would have had a slightly different effect on the functioning of the area, perhaps compared to what we're looking at under the proposed development and any implications that might have when we start to look at just how much replacement land is needed to mitigate the effect of the current proposal. Mr. Shuttleworth.
To a degree, Yes, but I would point out that I'm not quite sure it came over quite clearly in Mr. Garbutt's comment that the A3 dual carriageway existed previous. I mean, the A3 itself, Portsmouth Road, has been on this alignment across the Commons for very many years, and the dual carriageway was already in place as a previous improvement to that on its line across the Commons where we see it now. Prior to the construction of the M25. So there was already a significant noise source in this part of the open space and common. And the obviously that noise decreased with distance going into that plot that you indicated upwards on the page, which the mauve coloration signifies the start of the common land as against the open space land. So as you go further north in that plot, then that road noise would diminish.
So it's Mr. Humphreys, if I might just add a point at this stage. Back in that Appendix C of the Statement of Reasons, the Special Category Land Report, it is worth noting that these very points that you're discussing are obviously acknowledged in section 2.7 of that report, which is why the ratios that are proposed by Mr. Shuttleworth and Highways England are lower than what was delivered for the original M25 scheme. So these points are absolutely acknowledged, but have been taken into account in arriving at the relevant ratios. But I give you the reference there, and there's no need to take you to it.
Thank you, Mr. Humphreys. I think it's fair to say, and everybody knows because we published, well, hopefully everybody knows, we published a unaccompanied site inspection note. I was able to undertake a visit probably about 3 weeks ago. It's very difficult at the moment to keep track of time, but it was about 3 weeks ago, and the matter of noise was something that I was, if you like, able to gauge during my visit, because even with much lighter flows of traffic on the M25 than might be the norm, there were still quite significant volumes of noise in and around this part of the application site, and therefore within or adjoining areas of special category land. That's why some of the questions I'm posing at the moment, that's a little bit of that context, just to advance and also to get a flavour for what all the sides in this debate feel about the relative advantage or disadvantage. Mr. Garbutt, I can see your hand up.
Yes, sir, thank you. The point was just made regarding ratios being lower than what was delivered for the M25. That's not actually my understanding. And as I said earlier, I think it would assist to have a note which consolidates all the different references perhaps with this, because I mean, if you would like to turn to the Appendix C Statement of Reasons document at paragraph 6.4.6.
Mr. Price, that's Rep 8515, if I remember offhand.
That is Rep 8015, yeah, correct.
And sorry, Mr. Garbutt, can you give the page number so that
it was page number 81.
Could you repeat the library reference for me, please?
Rep 8-015. So that's the latest version of Appendix C.
And the page number as well, please?
81. I think that was the number you gave, Mr. Garbutt.
I did, 81. I might need to look at 80 as well, but 81 is the main point. So So if you can see that's the summary of the, I think the final reckoning, the ratios in relation to land to be acquired for permanent loss of special category land. So that excludes what I think is a very significant factor, and we'll come on to this, but the fact is this scheme is compensating at 1-for-1 ratio for order rights, where that would cause or is perceived to cause a disadvantage. But this is the stripped down ratio in relation purely to common land and open space, and those figures are much higher than what has been quoted for the historic schemes. Now, those figures that you see there, 3.4 to 1, 3.0 to 1, and 2.5 to 1 for open space, the first two are common land, don't give you the full ratio when it's blended, but I worked that out as, I think, 2.9. So in other words, the overall ratio of replacement land to special category land that would be lost is 2.9 across the scheme. Now, obviously, the applicant can confirm all of that, but if that's the case, then we are talking about ratios which are, contrary to what Mr. Humphreys has just said, are actually significantly greater than were actually approved under the M25 scheme. And those ratios only come down when, and it might be helpful here to turn up page 80, which is the previous page, 6.4.4. As I understand it, those are the calculations for the replacement land measured against land that would be lost, and including the land affected by order rights. I think that's correct. So it's a combined total. And obviously there is a lot of land that is being affected in that way. So I just want to draw your attention to that, because I think it makes a significant difference in the sort of conclusions being reached about whether this is more or less than what was previously suffered under the M25. Thank you.
Mr. Shuttleworth, are you able to help with that blended figure that Mr. Garbutt's just referred to? His approximation, the blended figure is of the order of 2.9 to 1, i.e. 2.9 hectares of replacement to every 1 hectare lost.
I could do a bit of arithmetic offline, but I would, looking at those numbers, that seems quite likely. I would just sort of comment that, of course, the previous historic scheme wasn't required to provide exchange land for any permanent rights that the scheme may or may not have burdened other parts of the special category land with. So this then is a comparison between the Planning Act requirements and the slightly different Acquisition of Land Act requirements that applied back in 1979. So that's my only real comment on it, that we're playing by different rules now. So the comparison that Michael Humphreys was making was to do with the ratios being applied in relation to compulsory acquisition of title.
I think to save too much discussion about lots of numbers which could get very muddy, I think what would assist the examining authority is if we can have a note that if it clearly sets out what the ratio was back in the mid-80s when the M25 was first built, and clearly sets out, as Mr. Shuttleworth has indicated, that there was a slightly different legislative regime that had to deal with that scenario compared to of course, the application, which is running under the Planning Act 2008, I think that would assist, and I say would avoid too much drilling down into these numbers, because it could get quite confusing. And I think it might be worth doing, if you like, a comparison between if the current scheme was running under that old regime, what the number would have been, versus what, of course, the proposal is actually working under the current regime. It might just help to demystify things a bit from the examining authority's perspective. And it also avoids both Mr. Jones and I getting our calculators out and possibly not quite interpreting the numbers correctly. Mr. Garbett, I can see your hand raised.
Yes, thank you. It was just really to conclude with those thoughts. I think the point has been taken on board, but just in case it hasn't, the parties are obviously at odds over the extent of the disadvantage caused by the order right. So that is obviously a key factor here in terms of that balance. But also, I think the point has been made that the legislative scheme was different. Well, in that case, I think one has to question the wisdom of following these previous schemes as a useful guide if one is actually comparing apples with pears. I mean, what I would say is that if under the old scheme all that was taken into account was the loss of land, then that is the only fair basis for comparing the schemes now, if one is going to be led down that path. I mean, obviously it's not our case that one really should have any reference to these ratios at all. That really the only important thing is to measure up and weigh up the importance of the land in value terms now, and to compare that to the value that would arise from the replacement land replacement parcels. Thank you.
Thank you, Mr. Garbett. Mr. Mitchell, is there anything that you want to add on this point, or are you content that the two respective positions have been set out? And I think it's fair to say that they are well known to the examining authority. There is a disagreement in terms of just how any ratios are worked out and how you go about doing it. But Mr. Mitchell, is there anything that you want to add at this point before we move on in effect to step 2?
Yeah, thank you. I'm not really able to sort of go into the detail or the rationale of the historic ratios, but I would just like to add a sort of general point, really, in that whilst we as the landowner don't have specific data on public use and the demand of that site in particular, our expectation would be that the usage and the need for it and the requirement is perhaps greater than it was when the M25 was first built. So that could be a factor that could influence the ratios in terms of increasing the value and therefore the ratio at which it's replaced if taken.
Thank you, Mr. Mitchell. That possibly anticipates a question that we might get to later, but you have raised a point. I think it's helpful that you've confirmed that the county council doesn't have, if you like, hard data about the use of the common lands. The applicant has undertaken a survey which indicates certainly preferences. I'm going to ask Mr. Alder for the Wildlife Trust, because of course the Trust in effect does a lot of day-to-day management in the area and may have a handle particularly on the level of usage that's put to, if you like, these 4 plots in and around Junction 10, which again we're using as a proxy, not necessarily as a key indicator across the piece. Mr. Alder, I presume you're still there. Are you able to assist in terms of level of usage and preferences amongst visitors to the area?
So it's Mr. Adler.
Sorry, Mr. Adler.
Right,
my
don't worry.
handwriting is getting worse, and my memory for names is getting even worse. And I'm going to blame my father for that because he suffered with that really badly.
No problem at all. So it's Mr. Adler from Surrey Wildlife Trust. There have been some surveys done in the car parks over the years, which was part of the agreement between the County Council and the Wildlife Trust. Those are obviously not referring particularly to this examination. They've been kind of visitor experience questionnaires done in the past. I'd need to drag through some of those. Just one comment on the visitor experience. Obviously, people say what they want to do. It doesn't necessarily always mean that they're allowed to do that. For instance, dogs roaming free on a special protection area for the ground nesting bird population is not necessarily compatible. So there's one point on that. But just in reference to your particular question about the use of those areas for access, people use the site in a variety of ways. So, for instance, if it is raining heavily, people go onto the tree cover more. And if it is good weather, then they go out onto the open areas more. Those 4 quadrants that you've shown also have a variety of uses of them. There is one particular user group that uses the quadrant close to Ockham Bights and does heavily go into that area, but that's not a normal, if that's the right use of the word, user group in that section, but you would have noted the paths through the woods in that area. The other areas, I think it's fair to say that people go along the rights of way that are in those areas, but they don't walk through, off those. And it's variable across the site.
Thank you, Mr. Adler. I think that provides some useful context. Does anybody feel the need to add anything to what Mr. Adler has said, or are you all prepared to accept Mr. Garbett?
Yes, I think it's just a more general point, really, and it also captures or responds to something that was said previously. The comments that we've just heard relate to the special category land as a whole, where, of course, we are interested chiefly with this test to work out what impact the scheme would have in relation to the actual order land being acquired. So I will obviously take on board the comments about the wider use, but actually it is the order land we must contain ourselves to consideration of. And the point was made that the land forms a buffer, and therefore it serves a function in that context. And the point was made that the buffer would move further back towards the existing common land, which I suppose must be more well used, if that's the logic of the point. But really, the only thing that matters in that context is the overall amount by which the commons would shrink. So perhaps one useful piece of data we could have is a rough and ready assessment or a close assessment in percentage terms of how much the existing block of Wisley Common, for example, would actually shrink. Because I think the point on our side would be that, yes, you switch a piece of buffer which you've used and you move that buffer slightly. So that is in one way a neutral effect. But the only real effect is the fact that you shrink the whole. But I don't think we're talking about a scheme here where anybody walking in the middle of the Wisley Common is going to notice that. So I think it would be useful in data terms to just know what we're actually talking about there. How much is this land going to reduce in size? Because when it comes to then assessing the benefit which comes from the other side of the equation, which I know we're coming on to, we've got a much better set of facts from which to make that judgment properly. So I would just put that point. Thank you.
Mr. Shuttleworth, is that a sort of number that you've got to mind in terms of how much special category land there is at the moment in total, and the quantum of loss that would arise from the proposed development?
I don't have those numbers in front of me, sir. I'm afraid that we can endeavour to find those out.
Yeah, I think that's something that will usefully be contained in the note that's going to follow from this hearing, unless Mr. Mitchell has any number that comes to mind.
No, I don't. Sorry.
Okay, that's fine. I think it won't assist the hearing if we try and get too heavily bogged down in numbers. They probably could be worked out, but it would take Mr. Shuttleworth a bit of time and sidetrack us from doing other things this morning, stroke early afternoon. I'd now like to do a very quick exercise, similar exercise, but hopefully very quickly now, just looking at the acquisition of permanent rights. So really turning to the applicant, can you just confirm the total area of land over which rights are being acquired and replacement land is also being provided?
Andrew
Yes, I can give you those figures. It's Mr. Humphreys. I can give you those figures if you want.
By all means.
The area of permanent rights, it's a total of, and I'll give you it in square meters and then hectares, 85,108 square meters. That's 8.51 hectares, and that's set out at table C4 of the Common and Open Space report, and of that,
Mr. Humphreys, I'm really not too concerned about any breakdown. The number is what I was expecting somebody to say, but it's just important that we get the numbers fixed, and I think we have, which means that with the ratio at 1:1, that's a nice easy one to work out. It's 8.51 hectares you're looking as a replacement for that affected. Turning to Mr. Garbutt, is that a number that's familiar to yourself?
I would actually, sir, not like to say without having the chance to look back at the various pages I was consulting, but I'm happy to take that as read. And
it was certainly the number that I was expecting to see.
I think so, but I just would like to caveat my answer in that way, if that's possible. And I'll certainly let you know if I see anything different.
Okay, I just want to look very quickly at one plot as, again, an example of functional quality. Mr. Price, if you can turn up, please, in the special category land plans, which is Rep 8-06. If we can have a look at sheet 3, please. And I'd like to look at plot 236, 2-36. Although it's prefixed 2, most of this land actually appears on sheet 3. And the plot I'm talking about is this one, which by now I think might have merged into another one. It doesn't really matter. The point is that it's a plot that adjoins the A3. Again, thinking back to the survey that the applicant did and as reported in Rep 8-015 a little earlier, we referred to earlier, to simplify things, is this a high performing piece of special category land, or is it a lower performing one in terms of user attractiveness or functioning? Starting with Mr. Shuttleworth. Mr. Shuttle.
Apologies, I was just momentarily distracted there by somebody sending me a message demanding an immediate response, which I deferred. HR, this is what happens. If you could repeat which plot that was for me, please. It was
we're looking at this, which becomes a public right-of-way or bridle-way under the scheme.
Okay, so it's the long plot running along.
Yeah.
Yes, I'd say that was a fairly typical example of the rights plots that we're looking at for the scheme. Yes.
But in terms of its existing functional quality, is it at the lower end or a higher end of current usage?
I can't speak to it in terms of usage because we don't have any specific data on that front. I would comment that there is a path running more or less along the line of the proposed bridleway, along the slightly set back from the existing A3. It follows, there's a grazing management fence there, so it's a path that's in part used by sort of Wildlife Trust, but it also takes you up and over Hut Hill, and in itself, it is that part is quite a pleasant path around that part of the scheme, albeit one of the noisier ones. So it does connect up. It also connects up to the footpath, public footpath that crosses Wisley Common and arrives at the A3, but clearly once it's arrived at the A3, it doesn't lead you anywhere else. You've got no sensible means as a pedestrian of moving around from there. So in effect, it provides the connection to that footpath north and south along the open spaces. So I'd put it in the middle, I think. It's largely deciduous, sort of scruffy birch woodland, open birch woodland. So you go up over Hut Hill, you're sort of a local vantage point there. You see a bit more widely into the area, a bit different in terms of character. So yeah, it's a middling area in terms of pleasantness and interest. As Mr. Garbutt will no doubt observe, it's still one of the noisier areas of the scheme, but in terms of its frequency of public usage, then maybe Mr. Adler or Surrey County Council Steve Mitchell will have more of a feel for that.
Thank you, Mr. Shuttleworth. Turning to Mr. Mitchell, any observations?
Again, I would agree with that assessment. I think its proximity to the road and the noise is a negative on it, but it perhaps is not as blighted by that as the land we were talking around in the immediate perimeter of the roundabout. And as I am aware of a very informal pedestrian use through there. So rather, it's not a statutory right of way, but I think the fact that clearly people have chosen to use that route probably gives us a rough indication that people want to use that route. So I think that would sort of indicate it's perhaps of a slightly higher value than the other land that abuts either the A3 or the M25.
Thank you, Mr. Mitchell. Mr. Garbutt.
Yes, sir, thank you. But these really aren't issues I can really usefully make any comment on. I'm not the most familiar with this area generally, and I'm not a user of the path. So I think I will just defer to the expert views on that and, of course, your own decisions.
Yeah, I would hope, Mr. Garbutt, you might have got a flavour for, at least we understand the sorts of points you're raising. And this question, if you like, is designed to drill down into particularly the suitability of applying the 1-to-1 ratio for land subject to the acquisition of rights. But if everybody's... Mr. Adler, sorry.
That's all right. James Adler from Surrey Wildlife Trust. Just to give you some background on that path, the path was created alongside the grazing fence, which was installed in the mid-2000s. There was no path there before, and that route was cleared and then is mown. And it is now fairly regularly used. So the only additional information I can give you is that when you create a path on the site, it does tend to be then found and used by members of the public.
Sorry, can you just remind me, you said it was created in what year approximately?
We fenced Wisley Common, I believe, in 2005. I'd need to check the exact dates for that.
That's okay. If I remember rightly, in reading one of your recent representations, that date tallies. I think it's referred to in the management plan.
It is.
Yeah. Mr. Garbett.
Yes, I think you were leading me to perhaps make a more general comment, so apologies for that. But I think just turning to the representations, this really does refer to I think the overall compatibility of what is being proposed to what is already there in terms of the user experience. And certainly there has not been any strong case made as to why these are essentially disadvantages in terms of routes that perhaps are going to be improved. And I think the more general point to that is that there are both advantages and disadvantages where that sort of thing happens. For example, it depends on the kind of user you're thinking about, but not everybody is fit and able, and therefore there might well be somebody who is able to make a journey along that on foot or whatever that wouldn't have been able to before because of the type of surface being improved. So I think the essential thing in terms of judgment is that one must look at the issues in the round and not assume that these are out and out disadvantages. One has to come to a balanced view.
Yes.
So if that was what you were asking me to comment on, then that's really where the representation is coming from.
In a while, we're going to come to a question that's going to look at, if you like, what interference there might be with some of these parcels that are subject to permanent rights acquisition post-development. But there is a question that revolves, and that might assist, because really what we're doing is looking at land that's affected, but then we also want to go on and have a look at precisely what is the scheme doing to the existing special category land, and trying to again look at the relative level of disadvantage that arises from the scheme's implementation. So I think, unless Mr. Jones indicates otherwise, we've got through step one, and we can now start to move towards step two. Mr. Jones, is there anything that you want to raise as a question at this point on the step one type issues?
I only had one question, Mr. Gould, and that's if I can take everybody back. We don't need to get it up. If I can take everybody back to the Statement of Reasons, Appendix C, paragraph 4.74 refers to surveys of users of the special category land, and there were some findings, and then it looks like there was a more detailed questionnaire as well. Refresh my memory. Do we have a copy of that into the examination? I'm probably looking at somebody from Highways England's team. That the survey that's referred to, so not the one on Thames Basin Heath SPA that's in paragraph 4.71, but the survey that's referred to in 4.74 of Appendix C, page 59, if that helps. Do we have a copy of that into the examination? If not, is it in a format where it could be submitted into the examination?
So I don't know the answer to that, but let us take that offline, find the answer to that, and then we can come back. We could maybe update you during this afternoon's session and just let you know what the answer is.
It's probably, I can put that in the form of an action point, Mr. Humphreys, if needs be then. Okay. And for you to go away and have a look, and if it is submittable, because it might just be raw data, but if it was ever knocked up into a report of sorts, if that report could be submitted if we don't have it already.
Thank you, sir.
Thank you. That was my only question, Mr. Gould.
Thank you, Mr. Jones. I've sort of got an overarching question before we get into some more sort of nitty-gritty questions. And really, this touches on a point that's been made at various points in the Part 1 farm representations. And it's really the role that should be played, remember, in the compulsory acquisition arena versus any other if you like, environmental impact assessment type considerations, whether in terms of looking at replacement, the provision of replacement land for special category land that would be affected by the development, there should be a consideration of environmental enhancements and or some biodiversity roles. That is something that is referred to in paragraphs 4.1.3 and 4.1.4 on page 45 of Rep 8-015, which is the latest version of Appendix C. I'm not necessarily suggesting that we get it up, but turning to the applicant in particular, I'm really just trying to get to the bottom of it. Has there been any muddling of seeking to address the loss of special category land, working out how much replacement land, vis-a-vis looking at some environmental enhancements and also a biodiversity role? Mr. Shuttleworth.
Yes, I can address that. There's two parts to this, really. One is that a significant part of the interest afforded by the special category land here is its biodiversity interest. And most of the special category land is designated as SSSI. A large portion of that is designated as part of the Thames Basin SPA. And then much of the remainder is designated as an SNCI, a local designation. So you could say that all of the special category land required for the scheme has a high biodiversity value, a high biodiversity interest, and that is one of the features that draws people to come and enjoy these spaces. So in looking at potential replacement land areas, we believe that is a valid consideration to look at what biodiversity they may already provide or may have the opportunity to provide with suitable management and suitable treatment, such that this aspect of the special category land is capable of being replicated or replaced in a similar equivalent way by the replacement land. Clearly, none of the replacement land has at the moment a biodiversity designation, so it's not acknowledged as being as of equivalent value in its present condition, but that's one of the factors to take into account. There's also then the issue of if a decision has been taken that a scheme includes areas of replacement land in the proposal as part of the consideration of the biodiversity balance of the project as a whole and the potential for mitigation and biodiversity enhancement measures to be included in the proposal, it is valid that the proposal seeks to make the best use of the land that it is acquiring in these for these purposes. So where the replacement land that we've currently got within the scheme affords opportunity for biodiversity enhancements, we've incorporated those into the scheme, and where relevant, those have been considered in the reporting of the impacts of the scheme in the environmental statement. So we think in those respects it is valid, but in terms of identifying, in terms of the principal reasons for providing and identifying replacement land, it is not a driver, but clearly it is a driver in influencing the choice of some parcels of land over others, if that is the position that we're in. But again, it's one of the factors to weigh in the balance, along with things such as contiguous connection with the special category land that exists, and ease of provision of access, and the quantity of and expense of work that might need to be done to bring these sites up to a acceptable condition. As with all these things, it's a blend of many factors.
So, in summary, in terms of your what you're essentially, I think, saying, and correct me if I'm incorrect, is that there has been some consideration of biodiversity, environmental enhancement, but it's in effect an ancillary function of choosing the replacement land, and it's something that is not getting muddled with the identification of mitigation for effects on the SBA and the habitat regs requirements, which it's difficult to say what regime or what category of land almost out trumps the other in this scenario.
Indeed, but I can say that
we're in the trumping situation. We are looking at SBA out trumping everything else because of its European designation.
You could say that it does, yes, but in this instance, I can clarify that the HRA is not reliant upon the opportunities that may or may not be afforded by the replacement land in terms of biodiversity value and biodiversity potential. So the mitigation for the SPA is, as it were, contained within the SPA or in the proposed additions to the SPA.
Yeah, I think the underlying concern is not that so much, it's whether or not there's some extra biodiversity enhancement going on within what might be the replacement land that is in effect overcompensating for any effect on the SBA.
Perhaps not the person to give you the root and branch answer to that, but in essence, the biodiversity opportunities afforded by the replacement land have been considered in the as it were, the non-SPA balance for the rest of the scheme. So perhaps more aligned to the rest of the SSSI than to the SPA part of the SSSI. And the other biodiversity impacts that the scheme has had, one of which, I suppose it sort of almost flips this around, is that part of the package of measures to provide a balance for the SPA is an increased loss of existing woodland because of enhancement measures within the SPA, which in turn then leads to a desire in the rest of the scheme to provide new woodland planting where practicable. So there is a kind of a tie-up with the SPA issues here, but it's more of a consequence of the SPA management rather than looking to, as it were, provide an input to the HRA balance.
So it's Mr. Humphreys. Again, some of this is touching on areas that are more the area for Mr. Watts, who you will remember from some of the issue-specific hearings we had. Can I suggest the best way we deal with this? I understand exactly the point you're raising, that maybe as part of a post-hearing note, we just kind of touch on these things and we can clarify what has been done. I think Mr. Shuttleworth has sort of given you the broad answer, but as he said, he's not the primary person dealing with the SPA enhancement.
Yeah, you must be a bit of a mind reader, Mr. Humphreys, because I was going to ask that might be the way to take this matter forward. I see Mr. Garbett's got his hand raised. Is there anything that you want to say that can be added orally at this point, or is this, whatever your point might be, actually something you'd need to see in writing from the applicant before we could develop the point further?
I was considering that very point myself just now. I think if a note is being produced, then I'm happy to deal with things that way. I suppose there is one thing, though, I'd like to say, and that there is an underlying point of law really in relation to this issue, and there is judicial authority on the point that one is only looking here at equality of the recreational user. One is not seeking equality of advantage in terms of equal ecological interests. I think that is the way in which you have just phrased things, but I think to the extent there is some muddling of that issue, it is important to clarify things. Certainly when one is looking at why users come to an area, I don't deny that the fact something as a triple SI is going to have some bearing on the overall ambience and visual quality of that area, but the fact it's a triple SI is actually irrelevant. So that's the sort of point of law and the general point I'd like to make, and I don't want to lose sight of that, because what we're really talking about is the user experience, not whether somebody comes with a long list of different creatures or whatever it is that they want to come and find. I mean, that in general terms is something which may attract them to the area, but it isn't something where we need to get bogged down in the competing merits of one piece of land and another. So I don't know if that is the line of thinking you were taking, but that certainly is my thought on it, and I think I could usefully expand upon that if I needed to. Yeah.
I think what's going to be useful for the examining authority at this point is that we have the note from the applicant looking at, if you like, at all the statutory designations in terms of what you're doing to mitigate effects there vis-a-vis the balancing up the recreational needs that's related to the effect on the special category land. Hopefully, in essence, I think Mr. Humphreys did read my mind a few minutes ago, but I think, yes, it shouldn't just focus on SBA type matters. We need to look at the SSI, because that's something that Mr. Shuttleworth has referred to, and we just need to be very clear that all the biodiversity concerns have been picked up in the mitigation package that is designed to deal with that, and that the replacement land is really being driven by its recreational function.
Yes, so that's well understood. I can absolutely assure you there has been no muddling on this. I've had discussions previously on this and things have been quite separate, but let's not debate that further. We'll pick this up in the note and explain exactly what has been done.
Yeah. And because time in the examination is short, is there any possibility of at least having some sort of offline discussion with Mr. Garbett so that he's got an understanding of what's going into that note? Because, of course, it will come in at deadline 11, and that doesn't leave very much time at the end of the examination for him potentially to make a comment on it, and then for you to react to whatever comment he might make.
So obviously I don't know the precise time it will take to produce it, but I have no objection in principle. That sounds like a very sensible suggestion that we would try and engage with Mr. Garvey.
I mean, it's almost, I'm suggesting that we might be looking at a new statement of common ground to try and just speed the process up of exchanging information and getting positions on it quickly, because we are now running out of time for this examination.
Yes, perhaps slightly confused by the concept of statement of common ground and speeding things up, but we will certainly engage with Mr. Garbett, and I understand exactly what you want to see happen.
You obviously haven't encountered me in the appeal environment. If I want people to speed up, they speed up.
So I'm obviously not able to read your mind quite as well as you may have thought, therefore.
I mean, yeah, I only suggest statement of common as it might be a vehicle, but I don't think the examining authority minds how you get there. But yes, something that just demystifies. There might have been some input from Park Barn Farm early, so that we got clarity literally as we get very close to the examination, at the end of this examination.
Understood, sir.
I should, I think, just ask Mr. Mitchell on Surrey County Council's behalf if there's anything that you want to add into that little dialogue.
No, nothing to add.
No, okay. It's only right that we ask. Right. We're actually going to get into the questions in step 2. Hopefully we can deal with these quite quickly. I'm going to ask Mr. Price if you can put up, please, page 86 in AS005.
If I can just interject there, Mr. Gould, it's now 1 o'clock. Would this be an appropriate time to break for lunch? I'm just wondering how much longer. Just before you start getting into questions, would we be better off taking a break now?
It certainly would be a convenient spot for an adjournment. I'm just conscious we're at 1. What sort of duration have you got in mind? Just thinking that we've still got a fair amount to do.
Yes, I was thinking, obviously, because we're all at our homes, we don't have to go to the sandwich shop, etc., etc. So would half an hour be appropriate for everybody? I shall work on Mr. Gould's approach. Unless I hear a no, then we shall take it for half an hour. I'm seeing some nodding of heads and thumbs.